Welcome back to Law and Crime Live. You just saw, we just received at least one verdict, and we got a verdict in the Brian Hyde case. And what we found, what the members of the jury found was guilty of second-degree murder for Dorla, Starlet, Michael Kelly, and Ari Kelly, which we now know was the baby that Starlet was carrying at the time of her untimely death. And so here we have it. We have it, Brian. We do have that Brian Hyde is convicted of second-degree murder here. We do know that he is an undocumented immigrant, so I would love to see if we can talk about that, if we can break that down a little bit. So we know that he is he's convicted now. He's found guilty of second-degree murder. So what happens now? So
what will happen now is it will get adjourned for sentencing. The judge will sentence him to whatever sentence is appropriate within the guidelines.
Right.
After he completes his sentence in Florida, he will be deported back to wherever his country of origin is. Having said that, what defense attorneys sometimes do, and very often it'll offend a judge's sensibilities, is say, Judge, he or she is going to go back to their country anyways, why waste taxpayers' dollars?
Right.
Because each of these people that are murdered, including the unborn child,
right,
deserve a fair sentence and justice in their own right. And so any defense attorney that does that really does it at their own peril. But in the end, this is someone that's going to serve out his sentence. It might be life, it might be the rest of his life, it might be shorter, and then will be deported to his country of origin.
Right, the country of Belize. I know that here at the Law and Crime Network, we were talking about a little bit before, off the air, about how he testified on his own behalf. Now, you tell me, I know that you have a lot of great experience practicing both at the state level and at the federal level as a criminal defense attorney. He stated on the stand that he could not remember whether or not he had killed the victims, and the victims in this case are Dorla, Starlet, Michael Kelly, and the unborn baby, Ari Kelly. Does that hurt the defense's case, or does that help?
You know, it's hard to know what's really going on in the back room between the defense attorney and his client. What you have to keep in mind is it's the client's constitutional right to decide whether or not he wants to testify. Strategic decisions are typically the attorney's purview, and he or she gets to make those decisions. But when it comes to the right to testify, that's a constitutional right that only the defendant and the client, which is one and the same, can make. So even if the attorney is jumping up and down saying, this is a terrible idea, this is the worst defense we could have possibly thought of, the client gets to decide.
Right.
So in this case, again, I don't know if that's what happened here, but he had the opportunity to testify, and he did. Now, what's interesting is he has some traumatic experiences. And so the way he kind of couched his testimony was, you know, I don't remember, but medically I don't remember, and this was backed up by other documentation, is I don't remember because if someone was murdered in my presence, I would have automatically blacked that out. So the problem is he doesn't point the finger at anyone else, where the jury's going to say, no, it was really John Doe or so-and-so. He's leaving this unanswered question, and that's hard.
Right. Well, Brian, I hate to cut you off, but we are seeing that there are a lot of people gathering in the Tex McIver case, so we don't want our viewers to really miss anything. So we want to take them live into. Well, we're going to keep it the way that it is right now, so that we can see, or I mean, we're seeing right now in the courtroom there are a lot of people gathered. We see both defense and the prosecution at the table right now. It's only 3:29, so I don't know if the members of the jury are like, "Hey, we're done for the day," or if we have a verdict. And so this would be, I think, like a first in the Law and Crime Network's history if we do get a verdict today, because that'd be like 2 verdicts at one time. And usually what happens is that we get like a hung jury, you know, with our luck. So let's hope that this doesn't happen here. You know, this can be a really exciting moment here in the Tex McIver case. And I know that we were talking to Ms. Hines about it before. You know, seeing these many people in the courtroom, what are you thinking?
If it's because the jury sent a note that says, hey, we have, we want you to gather, it's because they have a verdict.
You think so?
I don't think they would have the, I'll use the word chutzpah, to say, hey, Judge, I know we told you 4 o'clock, but we want to get out here 30 minutes early, and we haven't made a decision. I don't think the jury is going to do that. In terms of a mistrial, the only thing they could do is say, Judge, we haven't reached a decision and we're hopelessly deadlocked. But then the judge can read them an instruction called the Allen charge, basically saying, no jury is going to be better than you guys. You've spent a lot of time on this case. You've spent a lot of time deliberating it. I have every belief that if you keep on trying, you'll be able to come to a verdict.
I'm glad that you brought that up, because a lot of times our viewers or people just in general who aren't familiar with, the everyday proceedings in a courtroom will ask the question, well, why is the judge going to send them back when they can't, when they inform the judge that they can't make a decision? And so, we do have that Allen reading, which if you wouldn't mind explaining that a little bit more for our viewers.
Absolutely. What it says is, we spent a lot of resources and time selecting you, calling witnesses to testify. You obviously, meaning the jury, paid close attention and taken this case seriously. We selected you to listen in on this case. We have no reason to believe that if we were to retry the case, another jury would be better equipped. And that's ultimately what would happen. And so there's a soft Allen charge that talks about that in a little more tender language. And then there's something called the hard Allen charge, which basically says, no, I'm serious, go back there and make a decision.
Absolutely.
One way or the other.
And I've received, during my time in the courtroom, I've seen the second one, where it's a little harder or more harsh. I tried cases out in New Orleans as a prosecutor, and I can tell you that, and I'm sure that you've seen this here in New York, that the judges will really, I guess, give some tough love to members of the jury and say, look, we're not leaving here until you make this decision. And I've been in courtrooms like 2, 3 o'clock in the morning until members of a jury have reached a verdict. I mean, talk to us a little bit about that.
And so often in some high-profile cases, they'll sequester jurors and not let them see their families, or they'll put them up in hotels, or they just won't let them out for certain periods of time for lunch. I don't know whether or not the Tex McIver jurors were sequestered, but again, the point goes to, we don't want you to come back Monday unless you have to. If you need more time, we'll give you as much time in the world as possible. If you have more jury notes, we'll read the testimony to you again. We'll let you see the gun again. We'll do whatever you need to come to a decision. But really, you need to talk this out and come to a decision until and when you are hopelessly deadlocked and you've given it your best efforts.
Absolutely. Great explanation by Brian Wagner here with us on Law&Crime Live. We're so lucky to have him here with us, especially with the day winding down. It's currently 3:32. As we previously told you, members of the jury in the Tex McIver case stated that they wanted to remain until 4 o'clock. So we don't know if people are gathered in because they think, we're getting closer to the end of the day and maybe they should just be there, or if it's because we may have a verdict. And so we're hoping it's the latter of the two, that we do have a verdict in the Tex McIver case. And I think that Brian has been providing us, with some great legal analysis in regards to just this case and how weird it's been, if we'll say that. We spoke with LaTonya earlier, who talked to us about having seen Tex McIver walk freely throughout the courthouse. So, starting from how this case began to how it's ending, it's just been, we'll say, one for the books, right?
Absolutely.
Yeah.
And even the motive, right? The motive is a typical motive. He killed her for money. But then it wasn't really clear if he even had access to her money. So from the very beginning, every step of this case has just been a little bit odd. And people that do it in real life, as you and I did, it's not that weird. Every case is different. It's not TV. It's not Law and Order.
No,
it's Law and Crime. It's real life is very different than what you see on TV.
Great point.
And when you kind of go through that in a trial, sometimes it's hard for our viewers to understand that this is not like a scripted TV show, but rather real life. And that's what this case is.
Absolutely. And, I'm going to pick your brain a little bit, because as a criminal defense attorney, it's your job actually to think outside of the box, to think creatively, if you may. And, but I'm going to actually ask you to, right now, if we look into the courtroom right now, you're seeing Annie Anderson live in the courtroom. We see that a lot of people have gathered into the courtroom. We wanted to show you that Annie Anderson is there live now. So we can only wonder what's going on there. It seems to be a lot of chatter going on in the courtroom right now. And there you see Danny Jo Carter. Also there, sitting, just discussing, I can only assume they're just discussing, hopefully, hoping that there'll be a verdict today. But just getting back to what I was going to ask you, I want you to, I guess, think from the other perspective. What could the prosecution have done differently in this case?
I think number one is make sure that their expert handled the firearm carefully before putting him on the stand.
Absolutely.
That would be number one. Number two is just, it's about selling a logical argument. If you don't believe in your case, then that shows to the jury. And if you're kind of convoluted and confused about what the motive is, that shows to the jury. So if you have a theory of a case, it better be the right theory, because otherwise the jury looks right through it. And the only person that really knows what happened is Tex McIver, because he was there. He knows whether or not it was an accident. He knows whether or not it wasn't an accident. And the only reason why I bring that up is an honest conversation between him and his attorney gives the attorney, the defense attorney, such an upper hand.
Right, it
because
does.
when they're really making a ridiculous argument on the prosecution side, the defense attorney gets to make the strategic decision. Do I just absolutely knock this out of the park, or do I just let it sit as a ticking time bomb?
Great point, because do you think that's probably one of the main reasons why Tex McIver didn't have to take the stand himself?
Absolutely.
Yeah?
A client testifying is the most nerve-wracking thing, because the case, when you put a client on, you're essentially saying, I think the prosecution proved their case beyond a reasonable doubt, and here's what I'm going to do to push it over the edge back to the defense side. Because if the prosecution didn't meet their burden, you almost always tell your client, there's no reason for you to testify. The case is done.
Right.
They can't win.
Right.
And so by going up and testifying, the client's taking a huge risk, because they don't know what the cross-examination, how it's going to go. They know what the direct is going to be, but the cross-examination is the scariest part. So you're absolutely right in terms of that.
Right, and we never want to go with the unknown when we're in
Yes,
trial, right?
absolutely.
That's something that we want to steer clear from. We still, ladies and gentlemen, we're still live in the Tex McIver case. We're hoping that something comes down pretty soon. It's currently 3:37. We do know that members of the jury stated that they only wanted to remain until 4 o'clock today. And so we're hoping here at Law&Crime Live that they do have a verdict here for us in the Tex McIver case. We did show you previously before that there are many people in the courtroom. We have both the prosecution and the defense sitting at their respective sides. We saw Annie Anderson. We also saw Danny Joe Carter. So these have been some key individuals who testified during the Tex McIver case. And they're there in the courtroom right now. We spoke about it earlier. People who were instrumental witnesses in this case decided to stay and stick through it and remain until the end of the trial. And we still have them here with us today waiting to see exactly what happens, right? Yeah,
and in terms of this case, whether there is a conviction or an acquittal, or is that the judge?
Oh, we do. I'm grateful. That's great. Oh, we do. We have the judge taking his seat at this time in the Tex McIver case. I'm waiting for, I believe there should be a court reporter who should be coming out very soon. We know that not much can happen without the court reporter there if they're not there yet. We do see the state of Georgia seal right now, but Brian made a great observation. No. Brian made a great observation that the judge has taken the bench. So we're getting closer, ladies and gentlemen. Hopefully it's a verdict. We're hoping it's a verdict and not that they're concluding for the day. But, we'll only be able to determine that once the members of the jury are brought out or once we hear from the judge himself. So, this is anticipation time. And talk to us a little bit, from your perspective as a criminal defense attorney, what's going on in your mind during this time?
So I talked before, if the jury's following your notes, you feel confident. But as soon as you get that final note that we have a verdict, doesn't matter how confident you are all of a sudden a nervous wreck. And you try not to let your client realize you're a nervous wreck, but you are, as is your client, as is the prosecution. Everyone across the board is nervous. Even the foreperson that has to read the verdict,
right,
he or she is nervous. But you trust that you did your job correctly, and you trust that when they're following your summation notes and your instructions, that they're going to come to the same conclusion as you.
Absolutely. And that's a great point that you brought up about notes, because in a lot of jurisdictions, members of the juries can't bring their notes, the notes that they actually took during the trial, they can't bring them back to the jury deliberations with them. So I think that's part of the reason why we may have a lot of questions, or they may want to see certain things over again. In your experience, have you experienced that before?
So as a prosecutor, you tell them, go back to John Doe's testimony, specifically his opportunity to observe, his opportunity to see the person that was doing the shooting. And then when the jury sends out a note to the judge, hey, judge, we want to hear that testimony again. In your mind, you're going, win for me.
Right.
But if what you told them the testimony actually was doesn't line up with what the testimony actually was, you say, okay, now I know I'm going to lose.
Well, I just want to cut in real quick. The judge is actually on the bench in an unrelated matter, but we do see Tex McIver. I believe we did see Tex McIver. I'm not sure if that was him or not, because we cut away from it. But we did. I did see Tex McIver sitting down. So, ladies and gentlemen, we'll let you know if anything does happen in the Tex McIver case. But in the meanwhile, we're still gonna continue to talk about it. We have Brian Wagner here with us this afternoon, and we are still on verdict watch in the Tex McIver case. Tex has been charged with the murder of his wife, Diane McIver. He claims to have accidentally shot her from the backseat of their SUV on their way home from their lovely ranch, right?
Yeah.
And we were talking about the financial motive here. Are you buying it?
I'm not. It's not that I'm not buying it. I'm not sold. Now, you don't need to prove motive, so it's not a necessary element.
Right.
But jurors want to know why something occurred. If you're saying he killed her, why? And although it's not necessary, it certainly helps illuminate the whole circumstances around the murder. In this case, it kind of seemed like she had her own money, he had his own money, and that it wasn't going to conflate, and even upon her death, it wasn't going to go to him. So why is that a motive? I'm not sold on it, but I don't need to be sold on it either.
No, you don't. And from my perspective as a former prosecutor, it just seemed like a red herring for members of the jury, because it wasn't something that was concrete. It wasn't, even though we know that evidence can be circumstantial, but they were referencing his finances. They brought in a financial expert. They were alluding to a supposed second will, but they were never even able to bring it in.
Yeah. And I think the prosecution would have been better served to just say, ladies and gentlemen, there's some things we're never going to know.
Right.
Why Tex McIver killed his wife. But we submit beyond a reasonable doubt, we prove that he did. Leave it at that.
Right.
And the judge would tell them, ladies and gentlemen, motive is not an element of the crime. You're not to speculate as to anything that's not an element of crime or anything that hasn't come into testimony. But because the prosecution kind of opened Pandora's box, now the jury is speculating like crazy.
Anything, right?
Yeah.
Which is ultimately what?
Which is not what you want.
Right. We don't want that at all, because then when you have speculation, then that leads to reasonable doubt. And that's the last thing we as prosecutors want. I mean, in addition to that, once the defense finished their case in chief, then we had the prosecution bring back some more rebuttal witnesses. And, sometimes that's good. But when it just comes to a point sometimes when you're just beating a dead horse, and you don't need to do that. When you're just hammering in on something that, sometimes the jurors may have gotten it. It may not be the way that you want it, but they got it. It's either they got it or they don't. And, I think that ultimately in bringing in some of the experts during their rebuttals, I don't think that it was absolutely necessary. I mean, what do you think generally in those terms?
So, to be clear, a rebuttal witness is a witness that you call after you put on your case in chief as the prosecutor, then the defense has finished their case, and then the prosecution gets another chance to call it a witness to correct whatever misinterpretation or misrepresentation the defense witnesses have left for the jury. Similar to redirect. When you question a witness after he or she's already been cross-examined, you save that.
Are we back in the courtroom, guys? I'm sorry. Sorry, viewers. I just want to make sure that you're not missing anything. We see that the judge is speaking on the bench So we want to make sure that we're not, he seems to be talking to the galley. We're seeing that the members of the jury do want to go past 4 o'clock. And so this can only mean, this is a great thing. Sorry, I'm getting a little excited here, but this is a great thing. They feel that they are making progress and want to work later, ladies and gentlemen. So that means that there may be a verdict today. I think that they're trying to push to get to a verdict. So once again, we have the judge here who is letting us know that the jurors want to continue deliberating past 4 o'clock. We're taking you live into the courtroom right now. Welcome back, ladies and gentlemen. We are still live in the Tex McIver case. And what we heard from the judge is that the members of the jury still wanted to continue deliberating past 4 o'clock, that they believe that they are making progress and that they want to continue and they want to work later. Brian, what does it mean?
It means they're close.
They're close, right? They're close. Do you think that they're leaning maybe toward one of the lesser included offenses? What do you think?
You know, that I don't know about.
Right.
One of the things that we talked about off air was maybe they've already decided not guilty on attempted murder or not guilty on murder, and they've been done with that since day one.
Right.
And that they're just considering whether or not he tampered with a witness. It was something that you guys were talking about in the last segment as well. We don't know. The truth is we don't know.
Yeah, we'll
what I do know is in my experience, I had something similar where a juror asked to stay late because they were close to a verdict, and it was 3 hours later that they gave us a verdict.
Right.
Similarly, on a Friday, late at night. So what a jury thinks is close, who knows?
That's true, but I do think that if they didn't feel that they were going to get anywhere, that they probably would have said, you know, Judge, we're done. We need to go home, and then we'll come back on Monday, right? But hopefully, and you're absolutely right, though. You're absolutely correct that we don't know how much longer it can take. It could take another. Maybe we'll be back at 4:15, or maybe we'll be back 9 o'clock. You never know because we don't know what's actually happening back in the deliberation room. So we're still live. We still have people in the courtroom, but we'll be sure to take you back in live once we get word that the members of the jury are back with a verdict. So what we're going to do now is we're going to actually throw to a clip. We're going to continue with the defense's closing arguments in the Tex McIver case because we feel that we're so close to reaching a verdict here. So let's take a look at that, and we'll see you when we get back. We're cutting away from this clip in the Tex McIver closing arguments so that we can bring you live into the courtroom. The judge is on the bench right now, so we're going to take you there so you don't miss a thing. Stay tuned.
To know who is here in the matter of Amy Tibbs.
We are still live in the Tex McIver case. It seems as if the judge may be handling some other matters while we are waiting for members of the jury to come back. This is something that happens quite often, especially since, this particular matter has taken up much of the court's day. So what they'll do is they'll try to expedite some other matters in the midst of the members of the jury deliberating. But I think this is still kind of a good sign. I mean, we still have the judge there. We're still there. We're waiting for the members of the jury to come back and hopefully provide us with a verdict, right?
Well, you hit the nail on the head last time by saying that the fact that they're asking to stay late means there's movement one way or the other.
Exactly.
They wouldn't waste their time. If 4 o'clock was a great exit for them if they wanted it, if they just said, we need to hit reset. But if they're really moving the case and they're having productive conversations, that's why they said, maybe we should stay later today.
Absolutely.
And so I think you're completely right. That's what they're doing. They're talking about the case one way or the other.
And do you think that, I know that, we can never predict what the members of the jury are deliberating back there. But do you think that at this time they're probably just trying to figure out which one of the lesser included offenses? Well, let me ask you this. Let me kind of scratch that a little bit. Because at the end of the day, Diane McIver she's deceased. She's dead. She was someone's, she was Tex's wife. somebody's friend. And so at the end of the day, whether or not it was accidental, she is dead. So do you think that they're taking that into consideration and maybe saying, well, we need to do something? Do you think maybe that may be a holdup?
You know, that's hard.
Yeah.
Right? They're definitely taking it seriously, and they're deliberating, and they're going over the case carefully. A lot of the times, juries do just split the baby and say, well, they didn't prove that it was intentional, so maybe it was just reckless. And we were just listening to the defense attorney's summation, and he's talking about how the gun is on an angle, and it's sitting sideways, and so if it was an intentional act, then you'd hold it upright, you'd aim it, and you'd pull the trigger. That's not what happened here. So was it unintentional and reckless? I think the jury can actually come back with a verdict about that. Whether or not they do, obviously we don't know, but I think that would be a more typical verdict in this type of case.
Yeah, I would have to definitely agree with you there in terms of splitting the baby. And you know, like we said, we don't know what's going on back there, but we do know that they're close. We do know that we're going to most likely have something tonight or today, hopefully, ladies and gentlemen, not too far into the night. I know that when we first started talking about this case today, you did bring up the fact of the accidental discharge of the gun by the expert during the case. Other than that, do you think that there were any key points that would lead to maybe Tex being found not guilty in this case?
That's really the one that I hang my hat on. There are other things in terms of the lack of motive that we talked about, but those aren't necessary elements of the crime. Those are just things that give circumstances and let the jury understand why something occurred. But really what it comes down to is that accidental discharge. And what were his actions immediately before and immediately after? What some of the pretrial motion eliminates were, they got rid of a lot of red herrings that we talked about before. You know, the fact that they didn't go to the closest hospital, they went to a hospital a little bit further away, which was never really a big deal. He wasn't the driver. And the fact that he didn't call 911, yeah, but they were driving to the hospital. And so all of those you could easily explain away if you're the defense attorney. Ladies and gentlemen, he just shot his wife. He was in shock. The only thing he was doing was get to the hospital. That's what his concern was. No one described his demeanor as kind of nonchalant and, don't worry about her, she'll be fine. She'll walk it off. I mean, no, he was acting as if he just committed a terrible mistake. So all those things go into whether or not he intended or if it was a reckless act. That's really what I would be concentrating on if I was the jury and the defense attorney.
I think that those are awesome points. Those are great points to make. In addition to that, we do know that we have the tampering with evidence. We have two of the counts that were dismissed previously, but we do have the one charge, which is with Danny Joe Carter. And I want to discuss that a little bit right now because, you know, Caroline and I talked about this a little earlier, is the fact that do you think the fact that he is an attorney himself may have played to his detriment a little bit? Do you think that he was thinking about the entirety of this unfortunate circumstance and thinking, okay, well, maybe I don't want to get Danny Joe involved in this, and maybe that's what I'll say, well, you know, just say that you came in later. I mean, what do you think about that? Because there are a lot of ways that statement could be explained, right? So
I think it works to his detriment in two ways. One, lawyers aren't the most loved people, generally. I don't know if it's the same in Atlanta, but I imagine it is. Second is that because he's an attorney, the jury, whether they consciously do it or subconsciously do it, are going to say, no, if they're really thinking he murdered her, then they're saying, of course he crafted the perfect defense. He's familiar with the system and how law works. Whereas just a regular citizen, someone who's not an attorney, no matter their education, you say, yeah, but did he or she really know the intricacies of reckless endangerment, reckless manslaughter, or something like that? So it does work to his detriment in that sense, that they give him a higher burden of what he does or doesn't know.
Okay. Well, that's a good way, because that's a good way to think about it, because I was thinking about it in terms of, you know, sometimes doctors do not make the best patients, and sometimes that's why you say, like, you never represent yourself if you're an attorney, or you never represent a family member, because you have too much invested personally personally to kind of think objectively. And I was thinking maybe he was just thinking about everything too much and, just kind of just said the wrong things. But unfortunately, that wasn't the only circumstance in which he kind of, I guess, misstated some things, because we do know that during his jail interviews, he also stated that he was worth a lot more than Diane, and we know that that wasn't true. I mean, what do you think about that?
I think that's pompous, and it cuts against him in terms of his credibility and his likability.
Right.
But it's still not evidence of a murder, I don't think. And maybe that's why the prosecution entered the financial records and other things of that sort. But in the end, as you and I both kind of said, it doesn't add up to much. And all it does is create confusion and a red herring and what should be a non-issue into another issue that the jury needs to think about. So all of those things just make him a little less likable. Going back to him being an attorney for a second, when you claim self-defense, and this is not a self-defense case,
right,
but one of the common lines of question by a prosecutor when a client testifies about self-defense is, when did you first learn about that? You didn't tell the police that you acted in self-defense. In fact, you told the police that you weren't there.
Right.
And it's not until you met with attorney Brian Wagner that all of a sudden you knew about self-defense. Well, the idea being that this isn't a real defense. This is just the defense attorney's fabrication.
Right.
Here, Mr. McIver is getting saddled with that right out of the gate because he's an attorney.
Yeah.
At least that's what I think the jury might be thinking.
That's a great point. That's a great point, saying that it can actually be used, his profession as an attorney can actually be used to his detriment. And I think that wonderful, wonderful point. What we're going to do, ladies and gentlemen, as we stated, we're still in verdict watch, but we think that we're coming closer to the end as the judge informed us that members of the jury wanted to stay past 4 o'clock because they think that they are making some headway. So it's currently 4:03. 4:04 at this point, 4 minutes past the time that they said that they wanted to stay. So we'll see what happens, and as we always do, we'll keep you updated as to what's going on in the courtroom. And once we know that there's something going on, we're going to bring you back into the courtroom live. What we're going to do now is we're going to continue on with the defense's closing arguments. We're going to take you to those moments, and we'll be back to discuss it when we get back. I know that you all are hearing some laughter in the courtroom, but we're not laughing here. We're not the happiest here at this moment here at the Law&Crime Network because we do not have a verdict today, ladies and gentlemen. I apologize. But the members of the jury at around 5 minutes past 4 o'clock decided that they were ready to go home. So they informed the judge that it's not that they were deadlocked or the judge didn't hear that they were deadlocked. It's just that they were ready to go home for the day. So he brought members of the jury back in to dismiss them for the day so that they can commence jury deliberations again on Monday. Brian, what happened, man?
It was a bit of a tease.
It was.
Don't worry, we're going to work late. And then they, 5 minutes later, like, we're not going to work late. And so if I'm reading tea leaves, what happened was they thought whatever the holdout juror was or holdout two jurors were, they thought they were making progress, and then they just threw up their pens like, I guess not, come back on Monday.
Yeah.
What was interesting, though, was the judge said he hadn't received any notes that they were hopelessly deadlocked. And we talked a lot about the Allen charge.
Yes.
And even off camera, we were talking about, would the judge accept a partial verdict?
Right.
But at this point, they haven't made any indication that they are deadlocked, so an Allen charge won't come, and they haven't made any indication that they've reached a verdict on some but not others.
Right.
So there's no reason to expect a partial verdict. It's really just kind of a wait and see and let them keep on working. Yeah,
unfortunately, we'll have to wait and see, ladies and gentlemen. But we did get one verdict today, didn't we? We got a verdict in the Brian Hyde case where he was found guilty on 4 counts of second-degree murder of Dorla, of Starlet, of Michael Kelly, and Ari Kelly. But unfortunately, in Tex McIver, we just didn't get there today, ladies and gentlemen, and that's okay. That's perfectly okay. Just means that the members of the jury are doing their due diligence. They're doing their jobs, and they're going through this case as they should. It's a little bit disappointing on our end, but we're happy that they're doing their jobs. What we're going to do is we're actually going to switch gears a little bit. We've been covering some criminal cases, but now we're going to switch to the civil side. Earlier this week, we had been covering the David Copperfield. We do know that trial has gone dark for the rest of the week and will resume again on Tuesday, April the 24th. With David Copperfield, who was on the stand. He took the stand and provided some great testimony, I'll say. We do know that in this matter, the plaintiff has sued David Copperfield as well as MGM as a result of his allegations of being injured during one of the last acts of David Copperfield's show. He is claiming some brain damage and also in addition to some other injuries, and has not specifically made a specific claim for damages at this time. So what we're going to do, Brian, is we're going to play a little bit of David Copperfield's testimony, and then we'll come back and discuss this case in depth when we get back. Welcome back to Law and Crime Live. We are closing out for the day. You just saw some testimony from David Copperfield. The David Copperfield trial will resume back on April the 24th, and Mr. Copperfield will actually resume his testimony on the stand. And so you'll be able to catch that on the Law and Crime Network when we come back on Monday. In addition to the verdict watch still resumes in the Tex McIver case, so we'll be sure to keep you updated on that as well. We look forward to seeing you on Monday, and we hope you have a wonderful weekend. Take care.